G'day, Nina.
Hi, Andrew.
You're wearing godly white and me devilish
like,
black, aren't you?
yeah,
I
we're
know.
very much in contrast today.
Well, actually, we're always pretty much in contrast, aren't we? We're just chatting before we came on. Over the next 3 or 4 weeks, I'm doing a mediation course to do alternative dispute resolution work, and sort of fun thing to do, actually, because for my whole life I've been punching people, so it's time that I brought them together.
They're teaching you new lessons.
They're teaching me an old dog new tricks. Can it be true? But I think it's a fascinating thing to do, because so much of our work at the moment, particularly in more difficult financial times, is actually conflict management. And so as a group, we thought, wouldn't it be good if we got an accredited expert in it to actually go and do that work? And it sort of fits in a lot of the work that I do with non-for-profits and other organisations in the consulting part of the business. So that means we're going to be changing it up a little bit as to what we look like. So sometimes it could just be me, sometimes it'll be Nina and Kim, but it won't be me with someone for the next 3 or 4 weeks. So there you go.
Which might be a welcome change, or you might miss him.
I know, we might see the numbers go through the roof, and then I know I'm redundant and I'll go into alternative dispute resolution. I want to have a chat to start with on this sacking of the union rep.
Oh, this was such a ridiculous case.
Can I just say, we have some cases today which are some pretty ordinary law.
Yeah.
Okay, and this is an example of some pretty unreflective, ill-conceived decision-making, and I don't think it's the people involved. I suspect it's the court itself. I was pretty disappointed when I read this case. So just quickly.
Yeah, so basically an employee and a union delegate had a spreadsheet of all the employees and whether they were union members or not, and if they weren't or they were unsure, it was just blank, and it was circulated amongst a WhatsApp group, and 2 non-union employees made a complaint and said they feared bullying and intimidation from other people.
At that stage, not an unreasonable thing to do, because remember, as an employee, you can't ask whether someone's a union member. So if you're an employee who chooses not to be a union member in a unionised workplace, there is a high level of vulnerability.
Yeah, but then they just went and fired the 2 employees for just the act of having the spreadsheet, with no evidence whatsoever that there'd been any actions taken against the people, and it wasn't clear of whether they weren't union members, just the fact that they didn't know what they were.
But the part that bothered me about this decision is at the heart of the decision, there was this implication that the employer shouldn't have even investigated it and should have just said, look, that's a non-issue.
Oh, I thought he said the investigation was really bad.
Yeah, well, the investigation was really bad. Yeah, it was really bad. But part of it is this idea that you triage a complaint when it comes in to determine whether it's investigative, and a proper reading of this would have told you straight away, well, no, that's just a misconception. But remember, there's an abundance of cases, like True Energy case, which talks about deliberate dishonesty, that says the rights of bringing a complaint are critical for people if they do feel subjectively unsafe. So what I don't want to come out of this case, which is how it's being sold a little bit, is you can chop and choose when to investigate if you form a view that this doesn't deserve investigation. If the person's raising a complaint as to how they feel and why, and there's evidence that suggests that could be right, your obligation is to do a proper investigation, not a half-assed one.
Yeah.
And this was a half-assed investigation.
Yeah. And if they hadn't done anything, then it would have been a workers' comp claim, risk of unfair dismissal, heaps of things. So definitely do an investigation if something comes up.
Yeah, look, let's chat about the Mohammed case. This is a new case. It's not actually doesn't talk about law much at all, but it's important to remember what are the facts that sit behind this. A case brought by a woman who said she was discriminated, treated badly through pregnancy, and if what she said was said to her, it
was pretty bad.
It's pretty bad. But she's going to run to trial, and there is a risk of cost if she loses.
So it'd been going on for a while, I think. They had mediation. I didn't know you could make these kind of costs. It was really interesting.
No, I thought it's really interesting because it's not a cost-based jurisdiction for a start, but obviously there is other elements which are being litigated, which could create a cost jurisdiction. But the risk comes that the school said, look, we've got $340,000 of costs if we run this to trial. The judge said, well, on a taxable way, you've at least got a $200,000. And this woman has come to us and said, look, there is no way I can afford to run this if I lose. I need there to be some sort of order to protect me because I've been wrong, but I shouldn't lose the opportunity to litigate because I can't afford to fight. So what a great case.
Yeah.
And the court said, yeah, we'll narrow it down to 40 grand as
because that's what is reasonable for the matter.
Yeah,
not the 350k because they had senior counsel for 6-day hearing or something. Yeah.
Anyway, look, I think we just spoke about this and thought, look, think about this, because there are times, because we only act for employers, one of the comments will come, look, they can't afford to litigate. And here's a case where a court's intervened and said, well, look, the cost to run the trial probably are $200,000, but we'll reduce the plaintiff's exposure to $40,000 because we recognise she would be unable to litigate and take that risk were it not for that. I'm not sure it's the greatest law, but it is a really interesting case that has occurred. And I think it's a bit of a red flag for people who feel that capacity to bankroll a piece of litigation against somebody on the basis you don't think they can afford it.
Yeah, I suspect we're going to start to see more and more plaintiff lawyers start to use these in discrimination cases because they've got nothing to lose.
Yeah, nothing at all. All right, well, look, interestingly enough, we've got a termination of an EA case. This is the Broadmeadows Disability Service case where they were arguing about an enterprise agreement having very, very generous leave entitlements and saying that this made them unviable. They'd had a $780,000 deficit in the year before. So they brought an application to terminate. And what's clear about the current law on termination is you can't use bargaining tactics to bring a termination, which is what happened in Curtin University and a number of others prior to the changes in the law. And there was argy-bargy that was going on between the union and the disability service, and it was exactly over these issues. And I think at the end of it, what the commissioner found is they gained no comfort from the CEO when he was cross-examined, because this was a 2.5% saving.
Yeah, it was going to save them $165,000. And I think it was really telling the fact that their consultation with the union over the termination was really, do you think we should bother? Because we're not going to give this up. So talk to your members, but we're not going to give this up. So it wasn't really genuine consultation.
No. And so this, I think, was another shot across the bow. And remember, when you go along with the Fair Work Commission, you're dealing with people which either side of politics they came from, which are mostly coming out of either union organisations or employee organisations, and they've seen it all before. So they're a very practical place. So when you're trying to sneak one through, you are, my father would say, being too smart by half, and you get caught out. So obviously the termination failed, and the court was pretty clear that, well, the commission was fairly clear, look, this is a bargaining tactic, and we're not going to terminate for you to gain leverage against the union.
Yeah.
I reckon we're talking about an outdoor business, which is the next case, which is a prosecution that's happened against a guy called Wright, who's a TV personality. He's already been charged on a separate offence, which may lead to his imprisonment, which is the death of a co-worker.
Of his co-worker, yeah.
But Northern Territory is an interesting place because industrial manslaughter in the Northern Territory is potential of life imprisonment. And what we've seen with the regulator up there, for such a small regulator, is a real willingness to have a go.
Yeah, they're very active.
Yeah. And look, this is an outdoor business, had people on a 30-foot boat, no seat belts, no proper...
Had more people than they were supposed to have as well.
Everything that looked safe was missing. There was no risk assessment. There was nothing.
And they hit a tree and then everyone fell off.
And 8 people were badly injured.
Yeah.
So why am I telling you a case about outdoor people? Well, the reality is, when you look at councils, when you look at schools, when you look at even business organisations who run outdoor events for clients, none of that takes away your responsibility for ensuring. Just because someone says, I'm going on an outdoor experience, I enjoy the risk, doesn't mean that they're meant to be taking any risk.
Yeah, those waivers and stuff. It doesn't protect you from the safety law.
Yeah, not at all. And this is a case where the directors and the company have all been charged. The charge against the directors is a pretty low level, which is due diligence and failure to provide a safe workplace. But again, what I love about the Northern Territory as a regulator is they're in there saying it. They're in there saying, yeah, look, when people go on outdoor events, they should be safe. They're starting to look at the edges of where safety is not often prosecuted in doing it. And we've seen it in Queensland with 2 school cases where people have drowned. We've seen it in Victoria, and we've seen it in New Zealand, that recreational activity, which is business activity, is now, I think, starting to go right up the scale as what regulators are looking at. So I think it's a good case. It's interesting. And if you're in the Northern Territory, I think you got a good regulator who's really giving it a bit of a shot at the moment. Okay, unrestrained stone, the Vanter stone.
Oh yeah, this one was interesting because I feel like they were trying, but they just didn't do enough.
No, this is sort of 360 kilogram lumps of stone that are lent against something. And you would think, I would think, being an uneducated and person with no science skill, that if you lay stone against something very heavy, it's unlikely to move.
But they had laid it against A-frames which had been designed specifically by an engineer, and they'd try to put in controls like these vertical bars to stop them from falling, but it was obvious that it could still fall. So doing not enough, as we often say, can sometimes be even worse than doing nothing
at all. Yeah. And look, it ended up crushing and killing a guy. And what we're starting to see here in New South Wales is a gradual increase in the base tariff. So nothing terrible here. 2 years ago, this would have been a $400,000 max sentence with a discount for an early plea. So you would have ended up at about 350, 320 sort of thing.
This was 600.
600, reduced
with
down.
25%.
Yeah, so what we are starting to see in New South Wales is the judges acclimatising themselves to a new jurisdiction with higher fines and lifting the fine base rate. So I think we've started to see that in Victoria. We've definitely seen it in Queensland. So up the eastern seaboard, there is this growth in tariff, which means what was a fine of 200,000 before is now a fine of 300,000, and we're going to continue to see that incremental growth. And as we see a higher level of prosecution against industrial manslaughter, that will pull the bottom ones up that go with it too. So again, not a fascinating case, but it's starting to show this change in the tariff of sentencing that's occurring. Safety Convention. Australians ratified the International ILO Convention on Safety. Why are we telling you about it? Look, the only major effect this is really going to have is where states start to erode safety entitlements under state-based legislation, you'll get federal intervention, or you get people agitating for ILO obligations, which are similar to European-based. That's where the ILO conventions are drawn from. So we've seen changes in governments affect what occurs. We've seen people slow march industrial manslaughter. We've seen all sorts of things happen. All the ILO alignment means is where governments seek to move away from what are current safety obligations, there will be litigation around breaching ILO conventions and preventing those walkaways. Now, we haven't seen it, fortunately, because all governments, either Liberal or Labor or National, as they now are, haven't walked away completely from the emergent safety law. But we will see it at some stage, and so I guess that's not a bad sort of safety net, is it?
Yeah.
South Australia, though, love to see that change in legislation there, which is
this is really interesting. Yeah. So that's the next slide.
Yeah.
The new protection scheme for retail workers. So it's not yet in effect, but essentially what they're planning to do is have a protection scheme where if someone has acted in a violent manner, even in a threatening way, like stalking, harassing staff, then a retail business can apply to the magistrate's court and get an order that they're banned from coming to the business for a year.
Yeah.
And any breach of that is, I think it's 5 years in jail.
Yeah.
Which is great because
good,
I think it's definitely needed.
I was in Springvale the other day, and what I love in Springvale is anyone who steals anything, they put photos up in the shop window of this. Do you know this person? They've all stolen. So there's about 8 shops with similar photos, I might add, of the same person that come around. But it is an incredible problem in retail. In fact, if I can give an example, yesterday when I was in our Adelaide business, there was a young man who's clearly affected by drugs, attacked a person walking to work, and one of our staff saw it, was incredibly distressed by it. But the fact is, with methamphetamine abuse and things, we have a very significant violence problem we haven't had before, and during recessionary times people are upset, angry, bitter, and there is no doubt the retail sector, the front line of retail sector feels it most. So I think this is a really good thing to do. I think our people do need protection.
Yeah.
So,
and I think once it's formalised, it looks like the other states are interested as well, which is good.
Yeah. So look, interesting things. Isn't it interesting how bits of safety keep emerging in different places? We've seen the ACT do all sorts of interesting things around sexual harassment. we're seeing Queensland do the same sort of stuff. So bit by bit, unfortunately, in a federation, people almost form pilots of ideas that gradually catch on. That's certainly what happened with psychological hazards. So I think this is a good step forward. Why don't we flick over to the main topic? Well, I've put a case in really just to have a bit of fun in the case, because the case doesn't help us a great deal. No.
But I think it brings up an important topic, which comes up all the time. Like, how do you protect the complainant?
And witnesses.
Yeah.
Yeah, so one of the things that happens to Nina and I, and it would, if it's not daily, it's certainly every second or third day, is we'll be involved in a piece of managing misconduct for a client. There'll be somebody who's genuinely scared of the person involved but raised the complaint, or was a witness, and they ask, say, look, I don't want to be named. But once you know of the information as an employee, you're obligated to act, and you can issue lawful and reasonable directions for people to engage in investigation and give information. But what do you do with people who desperately are fearful that there will be recriminations? And so we've got this case, which is Kemps case, which is a case where the ombudsman actually accidentally released the name of the complainant, and the complainant brought a claim saying, you've now put me at risk and you've got a duty to prevent that.
Yeah, but sorry, they brought the claim against their employer because the ombudsman told the employer their name, and then it spread, and they said they said they were faced with bullying and stuff like that, like people weren't talking to them and things like that, so they got an adjustment disorder as a result.
Yeah, now there's a person who already had a psychological vulnerability,
which was unknown to the employer.
And the employer said, and the court found in the end, that look, much of the people identified who it was by the nature of what the complaints were.
Yeah, it's the same complaints he'd already raised.
But then the decision sort of went one step further and said there is no obligation on an employer to protect a complainant from the impact of them being identified.
Which is just crazy.
Which I think, to be clear about the law, that is absolute bullshit.
Yeah, so, that goes against safety law.
Yeah, and it does show how common it is, Nina, that people who practice workplace law don't understand that safety law is the primary law.
Yeah.
But it also doesn't understand common law, doesn't understand workers' compensation law.
Yeah.
So it's a shocker of a decision. But it does give us this thing of saying, well, look, what happens when you do have a vulnerable complainant? Does that person have to become a complainant? Are you obliged to show a respondent all the evidence that you have? Now, you may think, well, that's not hard. You just give them an allegations letter. Well, that's actually not what the law is. And if you go back to the baggage handler cases, what the High Court has actually said is that there is an obligation of fairness that exists in any investigative process, where a person must be shown both evidence of what they did wrong and evidence which would allow them to show that they didn't do something wrong, which means the videotapes of baggage handlers sticking their hands in and knocking stuff off. Well, they didn't show them any of the videos of them not knocking stuff off, and therefore there was issues around fairness. So the answer is, when you're doing an investigation, you've got to understand there is an obligation of disclosure of relevant evidence. Does that mean you've got to disclose the name of witnesses? Not if the nature of the evidence is such that objective evidence is sufficient. But if it is the person involved who you did the wrong to, you can't seek to hide that person because there's no alibi. There's no, well, that person wasn't there.
Yeah.
I need to know who you say I bullied. So what can you do is a much more interesting question, because you can be creative. Remember, in safety law, your obligation is, once you identify a hazard, someone says they've been hurt, your next obligation is to look at what is the level of risk. And part of that risk assessment is the investigative process that's undertaken.
But also, I think, like, if there is a risk of safety, like separating the people as well.
Yeah.
Whether that's, suspending someone or changing reporting lines, all of those steps need to be taken to ensure it's safe for everyone.
And that's the control stage, when you get to control. But at the risk stage, what you can do is say, okay, I'm aware of these things. I'm aware of the vulnerability of the complainant. I have evidence which sits outside of the complaint, which would allow me to own that as a business, and it is the business that brings the complaint. And therefore, I don't have to identify the person as a complainant. They're simply a witness and a target of what occurred, and therefore the organisation can protect them. So you are allowed to do that. But when it comes to what evidence you show, your first obligation, of course, is to put the allegations letter. But if you collect other evidence which is relevant, the person should be able to respond to evidence which could allow them to alibi or to provide an alternative excuse. You've got to show it to them. So be really careful what you ask for. And I think we've probably said it far too often, but please plan before you start to investigate. We've been running a lot of investigation cases over the last 4 or 5 weeks for one reason and one reason only, to show that what you do at the beginning is the most important thing, how you prepare. So no, a complainant doesn't always have to be named as a complainant. The organisation can become the complainant, but they are a relevant witness, and if they're the victim of it, they'll definitely have to give evidence, and that evidence will definitely have to be shown to a person. So please be careful and never, ever, ever promise anonymity, because you actually don't have that power.
Yep.
Okay, so that's the notes. Why don't we try the problem anyway, because the problem sort of teases these ideas out.
Matilda was tired of Roy's behaviour. She was struggling to sleep, had palpitations, and her mind raced with thoughts of when he would behave badly again. She'd been his PA for years. Ingrid had been a friend of Matilda's for nearly 20 years, sitting next to her at work and seeing her outside of work. She hated Roy. It's not that he was outright rude, nor that he meant harm, but when pressure built up on him, he would take it out on everyone else. Roy was the CEO of Blue Ideas, a superannuation investment business. The Reserve Bank's intransigence
Yeah, I'll put that in for you.
on interest rates had caused investments to drop. As he felt the pressure, he'd asked more from Matilda. Things he did that were problematic became her problems. His focus on key issues dropped off, and others started knocking on her door for answers as he was not responding. Ingrid spoke to HR. Her friend was falling apart. The HR manager spoke to the chair, who had also noticed the problem. She had been chair for 10 years, loved Matilda, but had recently seen how damaged she seemed. The HR manager came back to Ingrid and drafted a complaint letter with her, but at the end, Ingrid said, "Please don't mention my name. He will kill me if he finds out." Vincent, an external investigator, was appointed. He spoke to Ingrid and had her sign a statement. He also spoke to other witnesses and finally to Matilda. Everyone signed statements but requested anonymity.
Anonymity.
Yeah,
no, I did it. I'm sorry.
No. Vincent prepared an allegations letter for Roy. When Roy received it, he demanded to see the evidence on which the allegations were based. Vincent explained that his duty was to respond to the allegations letter, and Roy denied all wrongdoing. Vincent found that Roy had engaged in significant misconduct by way of psychological hazards, including bullying Matilda. At his show cause meeting, Roy demanded to see the evidence against him, identify the complainant, and view the full report from Vincent, which had been commissioned under legal professional privilege. The chair explained that Roy had been shown the findings as they related to him and no further information would be provided. He left the room saying he would see his lawyers. Was there an obligation to disclose to Roy who made the complaint?
No, and I guess that's the first thing is the origin of the complaint doesn't matter. It's the evidence that does matter. And that's obviously, if you do have a complainant who gives a complaint, the evidence of that complaint will form part of a brief of evidence that goes to an investigator and therefore ultimately may have to be disclosed, and what we spoke about before, to the respondent. But no, there's no obligation here, because what the organisation did was they raised the complaint as an organisation, even though Ingrid had been the person who started. Was there an obligation to disclose to Roy the witness statements from other people involved in the investigation? Well, look, I just want to say this now. It's one of the reasons I hate witness statements, and why I prefer that you take handwritten notes, is that once you create a witness statement, you create an expectation that you'll be showing other people's witness statements. And if you're not shown with the sufficient clarity the evidence that appears in those witness statements and where that evidence is perceived and who it's from, then you've got this problem where you're probably reaching the Ansett baggage handlers case from years ago. So, for those people who love to create witness statements, bit of a rod for your own back, guys, just let me say. Was Roy entitled to disclosure of Vincent's
to require the disclosure?
Yeah. So this is one of the great maritime cases which talks about findings and reports under privilege. Can I say there is a way to prevent this from occurring, and that's the dual privilege approach, which we can talk about another day, but where you just have someone who does it under legal professional privilege, and they're doing it in this case under privilege because there's multiple people making complaints, and there's been a failure to act. So there is information that is going to come out which reflects the organisational culture, which they don't want to give to Roy. And they don't want to give it to Roy for two reasons. One, he says, well, you can't blame me for what the culture is.
Condemnation.
And secondly, it allows changes to be made which are different than just Roy. So what this case said is Roy is entitled to findings in a report, irrespective if it's under privilege, but it doesn't waive privilege by providing him with those findings that relate to him.
Yep.
Now that sounds good, doesn't it? Except the way they determine that is you have to hand up the report in a yellow envelope to the commissioner or the judge who's involved, who then makes a determination whether privilege should have applied and the extent of the level of disclosure that's made if you don't get it right. So can you just remember, nearly all investigations can be done with an open findings. If you want to have something done in privilege, which is conversations that arise out of that, it is something you can separately engage in above. You don't have to do them both. But again, misusing legal professional privilege or not having a sophisticated process is another rod for your own back that makes things very confusing and conflicting. And Roy's starting to win. Can you see that?
Yeah.
By the process you've adopted, Roy is starting to get the leverage he needs to say, you're not giving me what I need. I can't respond to what you're doing. Now you're hiding stuff from me, and so it goes on. So let's go to number 4. When Roy refused to participate in further discussion of the show cause meeting until he was provided with the documents he sought, his employment was summarily terminated for wrongdoing found by Vincent and for failing to comply with lawful and reasonable direction to complete the show cause process. I think I should have put punctuation there.
Yeah.
You know, like I think that really
missed the longest question ever.
I got a great set of lungs, but I only died halfway through. I went for the Ventolin. Does Roy have a viable general protections claim? Could he claim the termination was a fundamental breach of his employment contract and bring common law proceedings? Would he have a good workers' comp claim? So workers' comp one's not there. But
I was like, what?
Well, what I want to say to you is the failure to actually have a proper process meant all the way through this he had a good workers' comp claim.
Yeah.
So just be aware of that.
And unfair dismissal too.
Well, he's probably too high for unfair dismissal. I'm going to say he's outside. Okay. He's not an award-based employee, and he's probably over that. But that's a good point. But as a general protections claim, he has raised a workplace right unquestionably.
The workplace right to get the information.
Yes, yeah. That he wasn't safe in the process. So I think he does have a viable general protections claim, and it is a fundamental breach of his contract not to provide him with procedural fairness or fairness under this High Court rule. And people don't get it. People think when you're dealing with a non-award-based employee over the high income earnings,
it doesn't matter.
Yeah, and the answer is if you just want to terminate someone on notice, then just give them notice and don't talk about it. But if you're doing it for show cause, then all these issues start to arise. So I guess the idea of this problem was really to highlight investigations need to be planned well. You need to determine how and when to use privilege, and you need to be satisfied of what is the documentary process you're going to go through and what is the onus and obligation of disclosure. Because what you don't want to be doing happen is being caught with your pants down in the middle of a termination discussion saying, you haven't shown me the right thing. So what do you reckon, Nina? Do you reckon that's a shot, or you're usually a bit more aggressive from the employer's point of view?
No, I think in this case, had they done a bit more, then it was defensible. But no, I think they're stuffed.
Well, there you go. I think that's it for tonight. Oh God, I'm going. I've had a very late night last night.
Give us a thumbs up.
Yeah, please give us a thumbs up and some oxygen. That was a very long set. See you later.
I will see you next week.
Bye-bye.
Bye.